Hi, Cavinder. Thanks so much for being here today. As I think many of our viewers would know, Singapore is really the seat of choice for international arbitrations, especially over the last 5 to 10 years. And I think there's no better person to speak to about what happens to awards in Singapore than you.
Thank you, Anu, and it's great to be doing this conversation with you.
The perception is that courts of Singapore rarely set aside awards. And when they do set aside awards, it's only in the very exceptional circumstances. And I think a recent judgment issued in the last year found that only about 20% of set-aside applications are allowed. So what are some of the exceptional circumstances that parties can expect an award will be set aside for?
Setting aside an arbitral award is a challenging enterprise. Certainly before the Singapore courts, few cases succeed. As you mentioned, that 20% figure was articulated by the Court of Appeal. The grounds that tend to be successful would be, firstly, I think, natural justice challenges. That's probably also because the most number of set-asides that are filed are natural justice challenges because they are easy to formulate. The second ground would be challenges to the tribunal's jurisdiction. Whenever the tribunal has decided that it has jurisdiction over an arbitration, there is a right to take that to court and to challenge that, and the court will look at that de novo. And so the court's much more willing to substitute its view about the tribunal's jurisdiction for any prior decision. The third ground I would mention is fraud on the tribunal. That's always difficult to prove because it's fraud. But if there is evidence, that can be a very powerful ground for set aside and has given rise to a number of interesting cases. And then finally, I think I would mention setting aside an arbitral award on the grounds that the arbitration was conducted contrary to the agreement of the parties. In the past, Singapore cases have limited set-asides on this ground, but recent cases, including from the Court of Appeal, have indicated that this ground may be seen more broadly by the court.
That's very interesting. I think the most common ground that we see in India, particularly for domestic awards, is patent illegality. What that includes usually is when an arbitrator acts completely outside jurisdiction, outside the boundaries of the contract, or takes a view or an interpretation that no reasonable person could ever have taken.
That's interesting. I don't think the Singapore courts would take up the idea of no reasonable person would have made this decision. It's Singapore jurisprudence that if an arbitrator got it wrong, that is not a ground to set it aside.
I guess my next question is then, do the Singapore courts apply different standards where there's a foreign party involved as against where the dispute is purely between two Singapore-based parties?
There is a different standard. Our legislation has an arbitration act which deals with arbitrations between Singapore parties, and then a separate international arbitration act which deals with arbitrations where one or more parties are not from Singapore. And the International Arbitration Act sets a very high standard for setting aside, and they're very limited grounds, and you have to find that ground in that act or else there's no chance of a set aside. All the things I've mentioned is specifically listed in the International Arbitration Act together with a number of other grounds. The Domestic Arbitration Act has essentially the same grounds, but then gives the court somewhat more discretion on the edges.
I guess the next topic after challenge, and it's really the buzzword today in India, is enforcement. Courts dealing with newer and newer issues of enforcement in India. What is it like in Singapore? Can we expect easy and quick enforcement of awards?
I think so. Things move quite quickly on that front in Singapore. International award can be registered just by one party filing the application, and an order is usually issued provisionally enforcing that award within a day or perhaps sometimes within 2 days. Once that provisional order is served on the counterparty, that counterparty has 14 days to contest it. If they do not contest it within that 14-day period, then the the provisional order becomes final. Of course, if there is a contest filed within those 14 days, then a hearing is fixed before a judge, and the matter does have to be argued.
And what are some of the grounds based on which a court may refuse enforcement of a foreign award?
So the grounds are very much similar to the grounds for setting aside. One can take a proactive stance to try and set aside the award, or the court can look at the enforcement, the resisting of enforcement, as a passive right, just waiting for enforcement to come, and then you can raise the very same arguments.
I think on that count, Indian courts are similar in that resisting enforcement is always a passive right available. Though I think we see the most common objection to foreign awards tends to be contrary to public policy of India. But thankfully, the Indian courts have been very pro-enforcement of awards, and usually public policy challenges are rejected. And a very narrow understanding of public policy is what is considered. One very interesting development that has taken place in international arbitration generally is the recent UK Supreme Court ruling of Kebabji versus Coot Foods. And I thought that case was very interesting because it highlighted the problem in dealing with any overlapping of different regimes. So just for our viewers, that was a decision where the French courts and the English courts took opposite views on whether an award was enforceable, and this against a non-signatory to the arbitration. And this was based on opposite views about what was the governing law around the arbitration agreement. The UK courts held that the governing law was English law for the arbitration agreement, and therefore refused to enforce it. Whereas the French courts took the opposite view, that it was the French law which applied, and proceeded to enforce that against the non-party, or uphold it against the non-party. I believe a challenge is still pending. But it would be great to get your thoughts on how you think this might play out in the Singapore courts.
I think the Singapore courts do pay a lot of attention to what other judges think about the same case, but more in the sense of trying to understand the other court's reasoning so that they would be able to then consider it themselves and decide whether or not they would go in the same direction or chart a different course. One case that comes to mind is the PT First Media case that was in Singapore, and the Singapore courts took a very different view of the enforcement action taken out in Singapore from the set-aside action that was being dealt with by the Hong Kong courts.
It's not a principle that has been tested too much in India, so we'll have to wait and see what kind of judgments come out now, especially given that there are so many principles of enforcement being tested in courts currently. I think it's quite clear that Singapore has a very robust regime to deal with challenges and enforcement of awards. But it might be good to get your thoughts on how Singapore courts deal with interim reliefs granted by tribunals.
There's specific provision in our legislation to recognize that interim awards can be enforced in a Singapore court. And so just like the final award, these interim awards can be converted into a Singapore court order. And even the Singapore provision really deals with an interim relief that's granted in a Singapore-seated arbitration. It's more challenging when you have an interim award in a Singapore-seated arbitration and you want to enforce it in other jurisdictions because many countries do not have such a provision.
I guess my next question is then, does the Singapore legislation provide for a right to challenge these kinds of interim decisions taken by tribunals?
No, the legislation doesn't allow that. So parties would get the benefit of being able to convert the interim relief to a Singapore court order, but that court order is sacrosanct. It really cannot be challenged in Singapore court. And the only way to turn that around is to seek a further hearing before the arbitrator.
The Indian legislation takes the opposite view. A decision of an Indian tribunal to grant or not grant interim reliefs can in fact be appealed before an Indian court. So I think that's an interesting difference between the two jurisdictions which parties should take note of. And I think that's all the time we have today, Cavinder. Thank you so much for your time. It was a pleasure speaking to you as always.
Thank you very much, Anu.